I would like to acknowledge all the dignitaries who joined us. First lecture will be taken by Mr. Gautam Narayan sir. Mr. Gautam Narayan has more than 18 years of experience in advising and representing clients in various matters, including matters pertaining to constitutional law, civil law, and criminal law at Supreme Court of India and various High Courts of India. He has worked on various government cases, including being appointed as special counsel for the CBI. Currently, he also represents the government of NCT Delhi in the High Court of Delhi. He will be touching upon the practices, procedure, and politics in Apex Court in the session. Thank you. I would like to Mr. Gautam Narayan sir.
Morning to all of you. I think all of you should really have a big round of applause for each and every one who's attended this session yesterday, today. The kind of enthusiasm, the drive, the energy that we've seen. I don't think any of us who are here as speakers had this kind of energy when we were in college, we were at your stage. So, applaud for yourself. And let me promise you one thing, if you can carry this forward into your professional life as you enter the profession, the world is your oyster. There is nothing that you people will not achieve, there is no heights to which you will not rise if you are able to kind of channelize this energy, carry this forward, work and study as hard as you have been doing. You really will make it big. Don't think of yourselves as a tier 2 law school, a tier 2 city. These are all mindless, labels. You are as good as anybody else, as good as the National Law School, Bangalore, or as bad as the Campus Law Center, Delhi. Okay? There is nothing to choose between any one of us. You guys will be absolute rock stars when you enter the profession. Just work hard. That is all that you need to do. Okay, I'll start by attempting to answer a few of the doubts that were raised in the question and answer session when each of my colleagues were speaking yesterday. And one sense that I got was this palpable feeling of anxiety, especially amongst the 5th year students. As you enter, what is in store for you? Where will you go? Will you find a good chamber? Will you find a good office? How do you as a first generation lawyer make it in the profession? This profession undoubtedly has immense entry barriers. Let's not kid ourselves. It is a very difficult profession. It will be difficult all through. It is difficult for Mr. Ghosh as it is for any new entrant that is coming in, right? So let not the entry barriers faze you or daunt you in any manner. And let me also give you some insight into who each one of us are. Each one of us is a first generation lawyer. None of us have any backing. We don't come from an established legal background. We don't have a fancy surname that we can really leverage. Where Mr. Ghosh has reached in the profession is purely because of his own efforts. So each one of you can reach there. You just need to challenge yourself day in and day out. Work hard. That is all that you require. Your best ally, your best weapon is yourself. Remember that always. Okay? Don't feel intimidated. Don't feel that you're lesser than anybody. Okay, a bit about myself. This is not false modesty, I am a below average, at best an average lawyer. The only reason I am here standing before you today is because I was lucky to find a chamber. My boss stood up for me. He did everything possible to give me the kind of opportunities, the encouragement, and every platform that was required for a person to kind of utilize, I got. And I am here today only because of it. So what you need to do is utilize your time when you're in law school, find good internships. How did I find my boss? I worked in an NGO for about 2 years. This was an NGO run by a senior advocate of the Supreme Court, Mr. Rajiv Dhawan. He used to run at that stage what was called, it is now defunct however, it was called the Public Interest Litigation Legal Aid and Support Center, PILSA. So he used to get in law students year on year and we would be trained by him under his tutelage. He also used to have practicing lawyers come in and interact with students who were interning and work with them on projects. So that is where I met my boss, Mr. Krishnan. Therefore, I am saying start utilizing your time now to find good internships. It is not about business development. Don't necessarily go for a corporate law firm. Don't necessarily go for some tier 1 city. All of that may not help you. Do your research, find a good office, an office that tomorrow you can possibly go back to, right? Now, to get into the topic, what they don't teach you at law school? To answer this question, I think all of us first must ask ourselves, what do they teach you in law school? What have you learned in your 5 years at law school? What law school does, at least what it did for me, was to give me a basic understanding about the core concepts of law. That's about it. When you enter the profession, you will find that what you learn is really only the tip of the surface. You really need to unlearn most of what you learn and learn on the job. You need to pick up new skills. You need to challenge yourself every day. You need to learn, right? So what you will learn out of law school is really what you require, the skills that you require to make it in the profession. When you're in court, for instance, even as an intern, I have seen young lawyers stand outside courts and talk and gossip. That is not what is required. When you're in a court for a litigator, go into the court, watch some senior lawyer arguing. Today, because of video conferencing, you have that opportunity sitting here. Log in, see people arguing. I did that all through the lockdown when there wasn't much work for us to do. Courts were still functioning. I remember I would log into either the Orissa High Court or the Karnataka High Court or the Gujarat High Court and see lawyers arguing. Every day is a learning experience, wherever you may be in the profession, whoever you may be in the profession. Don't kid yourself. Learning is an everyday task. Okay? Work on yourself. You are your project. Improve yourself all the time. The more you work on yourself, the better lawyer you will be, the greater heights you will scale. There's no doubt. Another question that the young man asked yesterday to Mr. Satyakam: what happens if a client wants me to do something that I know is wrong, may not necessarily be within the bounds of ethics, but yet I need that money, I need to meet my rent, I need to meet obligations. What do I do? That's the conundrum that at least that boy had expressed. Well, my answer to that, just to add to what Satyakam said yesterday, is do not compromise. Okay? Each one of you is an original. Find your voice. Once you find your voice, your story will be told. Okay? And in every lawyer's life, there comes a time when you have to decide, there is an ethical line that you will be confronted with. There will be a temptation that, chalo is baar kar leta hu. I won't make this a rule. I won't make this a practice. Let me just bend the rule a little bit this time. Let me compromise. Next time I won't do it. I'm promising you, you do that once. That's it. There is no going back. You bend the rules once, you will become one more shark in the dirty water, as John Grisham said in that book. Don't do that. Do not let your guard down. Always, always, always take the high road. And like I said, keep evolving. As René Descartes said, cogito ergo sum. I think, therefore I am. Always think of what next. How do I become a better version of myself? What is the skill that I need to pick up? I know of people who during lockdown, while there was no work for them, enrolled in new courses. Not necessary, and this is about lawyers, picked up a language, entered a course not necessarily related to the legal field. Why? Because that is how you improve upon yourself, right? The next off-task question that people throw up during the profession is, during their professional career is, okay, I'm working in a chamber. What do I need to do? How do I impress my senior? I think one of the questions asked to Mr. Ghosh yesterday was that. Make yourself indispensable in your chamber. Your senior must rely on you and nobody else. So every brief that is allotted to you, every task that is assigned to you, do it to the best of your ability. Do it in such a manner that nobody else could have done it better. Okay? Once your senior starts relying on you, believe me, your professional career is made. Because that person then, wherever you may be, will always reach out to you when he is in need, he or she is in need. 4 things that you will need in the profession. You'll need commitment, you'll need dedication, you'll need hard work, and above all, you will need passion. An undying dedication and passion to law is what will eventually help you to succeed in the profession. Okay? So never lose sight of that. Do not, Ms. Mattu said yesterday, there is no attention that is unworthy of your attention, no detail that is unworthy of your attention. However small, however insignificant it may feel to you, do not miss out on paying attention to the small things, because that is what leads to big blunders if you overlook the small things. When to go independent is the next conundrum that most people face. Should I stay in this chamber? How long should I stay in the chamber? Increasingly, I stayed with my senior for 10 years before I branched off. I became an AOR in 2009. I joined him in 2001. So almost 9.5 years I worked in this chamber. Nowadays I see young lawyers wanting to branch out within 6 months. Within a year they feel, oh, we know everything. Enough is enough. Now I need to start my own office, set up an office in a fancy locality, buy a new car, show to a client. That's one facet of business development that is now oft spoken of. A client should feel that this lawyer is worth the money that I am paying him or her. I mean, that is the most foolish, piece of advice that anybody can give a lawyer. A client doesn't come to you because you drive a fancy car. He doesn't come to you because your office is in some fancy locality. He comes to you because of what you can offer. Law is a service. If you can satisfy your client with good legal advice, your client will always be faithful to you, irrespective of which locality you're sitting in or which car you're driving, right? So don't get swayed by these peer pressures of somebody else suddenly seeming to have made it. All of that is irrelevant in the long run. So in essence, what I'm trying to say and convey is, be honest with yourself. Each one of you knows whether you have worked hard enough. What you do is who you are. Okay? So work hard, be honest, challenge yourself, and keep evolving. I will now deal with the topic that has been assigned to me, which is the practice, procedure, and the politics of the Supreme Court. Now, how many of you, if any, have done an internship in the Supreme Court? Have any of you worked there? You have?
Yes.
Okay. Which year? When did you go?
Sir, in the last semester.
Last semester. Which office, if I may ask?
Sir, Advocate Rohit Pandey.
Rohit Pandey. Okay. So, since a majority of you haven't really seen the Supreme Court, let me just tell you what the Supreme Court is about. The Supreme Court has its own peculiarities as a court. Many of the features that you will find in courts across India are not found in the Supreme Court. So what are they? One, as you all know, the Supreme Court is the last court of appeal. There is nothing beyond the Supreme Court, right? So what essentially happens is the Supreme Court has divided its working week into Mondays and Fridays, which are the admission days. The fresh cases that are listed in Supreme Court are listed on Mondays and Fridays. Tuesdays, Wednesdays and Thursdays are days when matters are taken up for final hearing. So they are called hearing days. So Mondays and Fridays admission days, Tuesday, Wednesday, Thursday are hearing days. For every Supreme Court lawyer, Monday and Friday is our bread and butter. That is when you can actually charge a client, essentially. The fresh cases come up on Mondays and Fridays, the big lawyers appear on Mondays and Fridays. Somebody spoke about an astronomical figure that a certain senior advocate is charging in the Supreme Court. In the Supreme Court, you need these big lawyers because 99% of cases get thrown out on the first day, on admission itself. It is only 10% or maybe less than that that actually make it for hearing, which is why these lawyers command the kind of fees that they do. Once you're in the pipeline, of late, you must have heard the previous Chief Justice as also the current Chief Justice have been working very hard on getting cases listed. That has been one problem that has been plaguing the Supreme Court, the pendency. How do you get a case listed in the Supreme Court? It is not like the High Courts where if you file a matter on one day, it will come up the next or the day following that. That is what normally happens in most High Courts across the country. In the Supreme Court, a case takes about 15 to 20 days to get listed on its own speed once it has been filed. So you have got a system of mentioning. Supposing you file the case today and you feel it's very urgent, you can go up to Court 1 before the Chief Justice's court, mention the matter and seek urgent listing. Again, something peculiar about the Supreme Court. Other courts allow this, but you really don't need to do that in, for instance, in the High Court, because by and large your matter will come up the next day. Supreme Court, your matter will never get heard the next day unless you mention. Another thing, in the Supreme Court, there is no single judge bench. Judges always sit in division benches of at least 2, or courts 1, 2 and 3, and I think 4 also now, sits in a bench of 3. We have now, after Chief Justice Lalit took over as the Chief Justice, a permanent constitution bench. So currently there is one constitution bench sitting in the Supreme Court every day of the week, even on a Monday and a Friday. So 5 judges sitting in a constitution bench hearing a matter of, for instance today, last week what was going on was the demonetization challenge. A very important issue, as you all know. So constitution bench matters are matters where every lawyer, every one of you I'm sure one day will get the opportunity to at least see, if not appear before a constitution bench. That is every litigating lawyer's dream. It's our aspiration to be able to argue before a constitution bench. I haven't got that opportunity yet, but someday I hope I will. The other thing about Supreme Court, peculiar to the Supreme Court doesn't give dates in matters. If your matter is heard today, it gets adjourned. All that the judges will say is list after a certain period, 2 weeks, 4 weeks, list in January. In the Supreme Court, you do not get a date. In every matter in the High Court or the lower court, you will get a fixed designated next date of listing. So that is again something that is peculiar to the Supreme Court. An expression that I found very odd when I first heard it is when a judgment is reserved, the expression used would be CAV. So I asked myself, what is this CAV? What does it mean? Fancy sounding Latin term. All that it means is curia adversari vult. It means judgment reserved. Supreme Court is still steeped in tradition, in culture. It uses these archaic expressions. Once a matter is admitted into the Supreme Court, under Article 136, if the judges decide to, after hearing the matter at some length, feel that it is something that requires further hearing, they grant leave. Again, very strange. What does that mean, leave granted? What it means is, the Supreme Court has decided that the matter is important enough for the law to be clarified or that point to be settled by a judgment of the Supreme Court. So, they admit the matter, and the matter then will come in the regular hearing list after some time as per its seniority. Let me now give you a few insights into where the Supreme Court came from. 28th of January 1950 and the 8th of August 1958, 2 dates. Anybody know why they are significant? What is the relevance of these 2 dates?
Because earlier in 1958 Supreme Court used to take hearing used to take place in the Parliament or something.
That's right. 28th of January 1950 is when the Supreme Court was inaugurated. in the Prince's Chamber of Parliament. That is when the first 8 judges of the Supreme Court sat for the first time. 8th of August 1958 is when it shifted to its current building. Now, once you go back today, log on to Google Earth and type in Supreme Court. It will give you an image of the Supreme Court as it does from the top down. The Supreme Court was designed by its architect, Deolalekar, as the scales of justice. That is what the building resembles. The central dome is really the fulcrum. And then it has 2 wings on the left and the right, which are the scales. And then you have the lawyers' chambers at the end of each limb. The architect's conception was that every matter that travelled to the Supreme Court, the judges sit in the center. They do not tilt to the left, they do not tilt to the right. So therefore, a very beautiful thought that the architect has put in play is that the judges decide unmindful of who is appearing before them, and justice is meted out equally to whoever appears in the court. What was the precursor to the Supreme Court? Does anybody know? What did we have in this country before the Supreme Court was constituted? Any guesses?
Come on.
Sorry?
Yes. Come on, sir.
Sorry, be louder, I can't hear you.
He is mentioning that privy courts were there, but Supreme Court precursor was the Act of 1935, I believe.
The Government of India Act of 1935.
Act.
What did that do? What did the Government of India Act 1935 do?
The precursor of Supreme Court was actually that particular act.
Okay, so let me tell you. We had in India, when the company was in charge under the Raj, we had the concept of Sadar Adalats. In the Mufassil areas, justice was administered by Sadar Adalats. Over time, the British Parliament felt that the company was getting too powerful. And therefore, the Parliament entered the picture and passed in 1773 a regulating act. The regulating act sought to divest the company, that is the East India Company, of its powers. And it sought to put in place a framework whereby justice could be administered both to the Gentoos, as they were called, that is Indians, Hindus, the natives, as also the British citizens. 4 high courts were set up, the first being in Calcutta, Madras, Bombay. The immediate precursor of the Supreme Court was the Federal Court. Yeah. So, it is the Federal Court which was really the court that used to interpret issues of some importance. Appeals from the Federal Court would of course travel up to the Privy Council. It was the Federal Court which was constituted under the Government of India Act 1935. So from 1935 till 1950, it was the Federal Court which administered justice. And you know, when the Federal Court was set up, it had the judges who were appointed to man the Federal Court were Maurice Guire, who was the Chief Justice. Who was Maurice Guire? He was a civil servant. He was the draftsman of the 1935 Government of India Act. His successor was Patrick Spence, a conservative MP. Amongst the Indian judges, we had Vardacharya, again a distinguished career but really non-controversial. We had Sir Shah Suleiman. Now what is Sir Suleiman really known for? He upheld the conviction of the accused in the Meerut conspiracy case, sent them to the gallows. We had M.R. Jaikar, a moderate politician, Zafarullah Khan, who headed the government benches in the Legislative Assembly. So the expectations from the Supreme Court, from the Federal Court, were not very high. Everybody, that is the Indians, the Hindus, did not have very high expectations from the Federal Court. The Federal Court, however, defied those expectations. They actually pulled up the government, reined in executive overreach, and gave voice to the dispensation of law in the country. When the Supreme Court was set up, in its first year alone, the Supreme Court heard over 600 writ petitions. Just take a guess, what was the figure that the federal court had heard in the previous year? In over 11 years of its existence, the federal court heard only about 169 cases. The Supreme Court in the first year of its existence had covered more than 600. In the first 50 years of the American Supreme Court's existence, it heard in a total about 960 cases. That is less than a case a year. The Indian Supreme Court hears, and as on date, 1,000 cases a day on a Monday and a Friday. So the Supreme Court is really, it is not wrong when people call it the most powerful court in the world. It sits at the very pinnacle of our judicial system. It holds sway over a vast swath of humanity. It interprets issues of law, constitutional importance, statutory issues. It can annul elections of the president, the prime minister. It can punish for contempt of itself. It has the power to transfer cases from pending in one court, in one state, to itself or to another state. It hears statutory appeals under various enactments, the Excise Act, the Income Tax Act, the Telecom Regulatory Authority Act, the Consumer Protection Act. The list is endless. So the power of the Supreme Court is limitless. It is unparalleled anywhere in the world. And today the Supreme Court has a sanction strength. Initially, like I told you, when it started, it had a sanction strength of 8. Today the Supreme Court has a sanction strength of 34, out of which there are 27 judges who are sitting today. So we have got 7 vacancies. We heard yesterday that Justice Dipankar Datta's elevation has been cleared by the government, so we'll have 28 possibly within the next week. So in short, the Supreme Court is a court that is immensely powerful. The buck really stops at the Supreme Court. It has been, over the course of its existence, about 73 odd years, really functioning as a lighthouse. It has steered the Indian democracy through very troubled times, through choppy waters. And by and large, according to me, the Supreme Court has stayed true to its core values. It has upheld the Constitution. It has upheld fundamental rights. That is why it is known as the sentinel on the QB. As regards the issue of politics, well, on procedure, the Supreme Court's procedure is channelized by rules that the Supreme Court has framed for itself under Article 145 of the Constitution. And these rules the latest iteration of these rules happened in the year 2013. Procedure of the Supreme Court is encapsulated in the Supreme Court rules of 2013. I won't bore you with the details. One aspect of the Supreme Court's jurisdiction which is not really emanating from statute or from the Constitution, but is really something that the Supreme Court has devised for itself, is what is called or referred to in legal parlance as the curative jurisdiction. In the Supreme Court, let me just talk a bit about this. In the Supreme Court, once a matter is dismissed, a case is dismissed, since it is sitting at the very apex of our judiciary, there is no further appeal to any other court. So if you've lost in the Supreme Court, you've lost. That's the end of the road. However, there are 2 options available. There is what is called a review petition that can be filed. What is a review? A review is a request made to the judges who had heard the case and disposed it of to reconsider the judgment on certain points that the lawyer or the party feels were not considered or were overlooked. These are points that the court may have not properly appreciated, and therefore you go back to the court and seek a second bite at the cherry, as it were. In the Supreme Court, again, one peculiar feature of the Supreme Court, a review petition is not heard in court. There are no oral arguments addressed in the Supreme Court in a review petition. In every high court or any other court in the country vested with the power of review, oral arguments will be addressed at the review stage. After the review petition is dismissed, what happens then? By a judgment in Rupa Ashokura's case, the Supreme Court really gave birth to this new type of a jurisdiction called curative, where the Supreme Court will entertain a challenge to or a request to relook the dismissal of a review petition. The only requirement that the court has laid down is it must be a judgment that is at least facially vitiated by bias or by violation of principles of natural justice. What according to you is violation of natural justice?
So we don't give the other side chance to express itself.
Audio alternate pardon, that's right. Special leave petition and a review petition the court will entertain. But that is a very rare circumstance that arises. And in order to file a curative petition in the Supreme Court, what needs to be done is you need to get a senior advocate like Mr. Sanjoy Ghosh to issue a certificate. The onus is then put on the senior advocate to study the papers and decide whether it is a case that is meritorious enough to be admitted in curative jurisdiction. So therefore you will have to first treat the senior as the judge, convince him that these are the fallacies in the judgment, and once a certificate is issued that jurisdiction can be invoked, the matter will travel to the Supreme Court in curative. But like I said, this jurisdiction is possibly used in 0.001% of cases. All of you have done the constitutional law class, I'm assuming you all studied constitutional law, right? So what according to you is fundamentally the most important article in our constitution? That is what the Supreme Court enforces. The right under Article 32. What is Article 32? What does that mean? Okay. So, can you go to the High Court under Article 32? What is the equivalent of Article 32 for the High Court? Is Article 32 and 226 the same? So what is the difference then?
Under Article 32, we can go for implementation of fundamental rights, and in other 226, we can go for fundamental rights and also for other.
Correct. So the focus of the Supreme Court is only on enforcement of rights under Part 3, fundamental rights alone. You people have read your constitution very carefully, I must say. So that is one jurisdiction that the Supreme Court exercises. It also, like I said, exercises jurisdiction under Article 129. What is Article 129? It is the power to punish for contempt. The Supreme Court, being a court of record, being a superior court, like the High Court, under Article 215, has the power to punish for contempt of itself. Again, a peculiar feature, you can't just walk into the Supreme Court and file a contempt petition. The Supreme Court either entertains a contempt petition suo moto, or on the permission granted by the Attorney General for India or the Solicitor General. In the recent, all of you must be on social media. According to me, the invocation of this route of contempt has been singularly misused in the recent past.
By law students.
By law students. We have had over-enthusiastic law students writing letters on every arcane issue under the sun and seeking the exercise of this contempt jurisdiction against any person. Contempt jurisdiction is to be exercised, and the Supreme Court has said this time and time again, very sparingly. It is not to be misused or abused in the manner that it has been in the recent past. So as law students, be very careful. Don't approach the Attorney General or the Solicitor General on a mere trifling. Okay? The Supreme Court, apart from Article 136, exercises jurisdiction of an appellate nature when matters travel to the Supreme Court on a certificate granted by the High Court. So these certificates are certificates to appeal. Then the High Court feels that its judgment requires to be looked at again by the Supreme Court. It grants a certificate to appeal to the Supreme Court. This is done under Article 132. It will be done under Article 133, 134. The distinction is, under Article 136, however, it is the Supreme Court which grants leave, as opposed to under Articles 132 to 135, where the High Court grants you a certificate. Under 136, the Supreme Court grants you leave to approach the Supreme Court. come to the issue of the last aspect of this topic, the politics of the Supreme Court. What, according to you, would this mean, politics of the Supreme Court?
So seen in high courts especially, that if some issues with the filing or something like that is there's a normal procedure, but for known advocates, there's a bypass for that also.
Okay.
This is what
Right. That's
mentioning is something there where.
So you're saying favored treatment or privileged treatment meted out to a certain section of lawyers. Okay. Interesting. What else? What else could politics in the Supreme Court mean? Think about it. I want an answer.
It could be master of procedures, education of judges,
The Supreme Court, then the Chief Justice allotting matters to certain judges, exercising his power as the master of the roster. Okay.
Yesterday it was talked about that how the elevation system collegium is working in its way and how questionable it is very time.
Right.
So that is also a very big part of politics, how things are going on.
Okay. So what you're saying is Supreme Court is not the process of elevation of judges in the Supreme Court is not transparent and it's not fair. Okay. It's biased in some sense, or at least
It looks like that.
yeah, could be. Anything else? Any other way that politics has, according to you, entered the portals of the Supreme Court?
So like the Supreme Court has sitting over the cases, those cases which are really important, like EWS or for that matter. Many other matters have been in the past 5 years. So in that way also.
Demonetization.
Demonetization for that matter.
CAA.
Yeah, many are there.
Okay. So you're right. All of these are facets of what could possibly fall under the broad umbrella of politics. But according to me, I would pitch this slightly differently. Dig a little deeper. According to me, the impact of the court as an institution on the governance of this country, that is, according to me, the court's politics. How do its judgments impact the lives of everyday people, the common man, the Aam Aadmi? And what are the beliefs that the institution itself stands for? That is its politics. You will therefore need to study the judgments delivered by the court over a span of time to really discern for yourself how the politics of the Supreme Court have been changing over the past 73 years. It has not been constant. This issue of favored treatment to certain sections of lawyers, some sort of lack of transparency in the manner in which judges are elevated. These are problems that have been plaguing the Supreme Court from its very inception, right? From its darkest of times, as Satyakam said yesterday during the emergency in 1975. This is something that has been a facet of the Supreme Court. It's not unusual, it's not new. It's easy to perceive. But that is not, according to me, the politics of the court. The politics of the court is really how its judgments intersect with the common man's life. That is what politics is really about for me, and for which I would suggest you should look at a few judgments, read those judgments, discern for yourself the issue that came up before the court and what did the court do, how did it mold the lives of everyday people. Have any of you read the judgment in Bijoy Emanuel's case? Bijoy Emanuel was the state of Kerala. Any of you read that judgment? Yes, that's right. It was called the Jehovah's Witnesses, where two girls were being forced to sing the national anthem. Right? They refused to do so on the ground that they said they are Jehovah's Witnesses and they will not, or they abstained from that direction. The matter travelled all the way up to the Supreme Court. Justice Chinnappa Reddy, who authored the lead judgment for the court, had very prophetic words, and which words, according to me, resonate with a lot of clarity today. And I'll just read that one line. It's the last line in that judgment. He says, "Our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it." This line was picked up 36 years later by Justice Sudhanshu Dhulia in the judgment in the hijab ban case. Okay? That is really, according to me, the politics of the court. Its ability to stand up for the common man, to enforce the simplest of rights that you and I may take for granted. The elevation of judges, favoritism, these are issues that really, according to me, are issues that will plague any institution, any profession. But the Supreme Court holds sway over such a vast swath of humanity that it needs to be open to a deeper level of scrutiny. And what do you scrutinize? The judgments of the court, right? It is these judgments that show us where the court is headed. The history of India, mark my words, is a mirror of the history of the Supreme Court. The court has really been, according to me, of the three pillars of our democracy, the judiciary is the most important pillar. It is the most powerful pillar. And the Supreme Court, sitting at the apex of the judicial system, is the most important institution in the country. Of course, a certain leader of parliament had called the Supreme Court judges electable tyrants. That's one view to hold. That the Supreme Court, since it interprets so much of law today, is really entering into the legislative field. But when the government does not discharge its constitutional obligations, it is incumbent upon the court to step in to remedy what it feels or it perceives requires to be remedied in. Now, so I told you about two judgments. You must read this. Read Bijoy Manual. Read the judgment in the hijab ban case. Read also the judgment in this trilogy, Sham Narayan Choksi's judgment. What is Sham Narayan Choksi famous for? The judgment came out in 2016. What did it hold? Yes, it made it mandatory for people to stand up in cinema halls and sing the national anthem. Ask yourself, was that necessary? Do each of us not respect our national anthem? Do we need to be told that we must stand and respect the national anthem? I posit we do not need to be told all of this. Respect comes naturally. It doesn't come because of a judgment of the court. And going now a little further back in time, again on the issue of politics, study the judgment in the bank nationalization case, R.C. Cooper. Study the Privy to Purse case, M.R. Sindhya. Look at the cow slaughter ban case, Mohammad Hanif Qureshi. All of these judgments will give you some insight into the politics of the court. The judges manning the court at that point in time, how politics have changed, how the court has maneuvered and yet kept itself relevant in this modern world. Finally, there's just one thing that I want to leave you with, and if you'll permit me, I'll read it out because it's too long. It's in times when I felt despondent, I felt frustrated, and that profession will make you feel that increasingly as you go along. Have any of you heard of Rudyard Kipling? Yes. One of his most famous works is a poem titled If. And I'll just read a few lines from it. If you can keep your head when all about you are losing theirs and blaming it on you. If you can trust yourself when all men doubt you, but make allowance for their doubting too. If you can wait and not be tired of waiting, or being lied about, don't deal in lies, or being hated, do not give way to hate. And yet, you don't look too good, nor talk too wise. If you can make dreams your master, if you can think and not make thoughts your aim, if you can meet with triumph and disaster, and treat those two impostors just the same, if you can bear the truth that you've spoken, twisted by knaves, to make a trap for fools, or watch the things that you've given your life to broken, and stoop and build them up with worn-out tools. If you can talk with crowds and keep your virtue, or walk with kings, nor lose the common touch. If neither foes nor loving friends can hurt you, if all men count with you, but none too much, if you can fill the unforgiving minute with 60 seconds of distance run, yours is the earth and everything that is in it. And what is more, you will be a man, my son, I will just paraphrase this and make it a lawyer. If you can do this, the world is your oyster. Okay? So, amazing guys, you've been a massively wonderful audience. You have been invigorating. We've had a wonderful time interacting with you. And I think I speak for all of my colleagues. Anytime any one of you want to come and work with us, intern with us, you're more than welcome. Okay? So thank you all.
Do anybody have any questions?
You want to have your coffee?
No.
No, please have your coffee. It's already good at it.
Go ahead.
So, yesterday also it was asked that I also wish to, someone wishes to be a junior, you a junior or you intern for that matter. You must have willing to see some few things in
Right. Great.
What was it?
Okay, so what I would like to look at when somebody applies to me is, I always ask people to give me some little excerpt of written work that they've done. So I believe every lawyer and that every student must read widely, read voraciously, read on every subject under the sun. Don't limit yourself to just the law. And bring that into motion by writing. Because when you write, your thinking gets evolved. Your command over your language improves. Right? So I always ask people to send me some sort of example of any written work that they have done. That is something that all of you must make a practice of. Start writing. Writing will help you hone your skills of research. It will also help you think with more clarity. In court, the topmost lawyers in this country are good and are at the top, not because they can speak English very well, but because they are able to cut through to the meat of the matter. And the manner in which they put across their point is so clear and crisp and simple that the judge has no option but to accept it, right? That skill is something that you need to work at. And how you start working at it is by writing. Start reading, start writing. Okay? So that's the answer to your question. Yes?
So I don't know how you put it in politics, but sir, when it comes to liberty, Supreme Court takes various stands. For example, on one side, Supreme Court says that bail is a rule and jail is exception. But on the other side, like we have seen recently in ED case, Supreme Court clearly held that whatever has been the anarchic law is constitutional. So
the PMLA judgment.
Yes, sir. So what is your say?
See, undoubtedly there are problems. We can't run away from that. Yes, the traditional rule has been that bail is the rule and jail is the exception. There are certain special laws like the PMLA and the UAPA, POTA, which is now repealed, which actually put in place a system which was the reverse. Jail became the rule and bail was the exception. It still is under UAPA. It really depends on, and that unfortunately is the situation, which judge your matter comes up before. There are some judges who are liberty oriented. There are some judges who will accept the government stand that this matter, quote unquote, is of a very serious nature. Releasing so and so person on bail will imperil the nation's security. That is what is thrown. And we have in Supreme Court of late the concept, although the Supreme Court itself has tried to course correct, documents being given across in a sealed cover. So the accused does not even know what is being presented against him to the court that the judge is privy to when he is going to decide that person's fate. Those are problems, but the court has been trying to sort out those problems internally. It has been through its judgment speaking out. There are judgments which have now said that that kind of seal cover jurisprudence is not acceptable. Similarly, in your case, for instance, a recent judgment, the example that you just gave me, a recent judgment, a bench of the Supreme Court released Gautam Narayan. He had been in incarceration for a long time. The court made it a point to ensure that the man was released on bail, right? There are examples the other way where people could not, people who have been in jail for ages, Sudha Bharadwaj for instance. These are cases which are troublesome, but the onus is on each one of us to find a solution, right? We can't always blame the court for these problems. We are the solution. We have to keep tilting at the windmills, we have to keep up the fight, and someday, somehow, the light will shine on all of us.
Just a follow-up question. So, it is not like the court is not deciding the case of ED or some this particular case X earlier also. In Pradeep Mahajan case, the court is held according to the virtues of criminal law. But in the recent case, the court has clearly outlawed whatever is taken in Pradeep Mahajan's case. So, I mean, it is wrong on prima facie. So, I don't know how to put it in a word, but it is wrong. So they also know, I mean, they are judges. Even you can ask from...
See, the beauty of the law is that it can be molded according to the beliefs of the judge who's hearing the case, right? The same proposition or the same statutory provision can be interpreted in two ways. What can seem very apparent and clear to you can be interpreted in a diametrically opposite fashion, okay? Which is why I am saying that it really depends upon who the case lands up before. What is the ethos of the person hearing that case? What are his beliefs, right? I wouldn't go so far as to, level criticism at the court. The court has done what it's done with the judge discharging his duty in accordance with his oath, okay? We or you, any member of the public, has the right to criticize the court, while of course not crossing the line where one of you will write to the Attorney General to ask for permission to prosecute the person for contempt. But while you criticize, and you have the right to criticize, you must also try and examine for yourself what the solution is. Criticism alone is not the end goal, right? So my suggestion is keep agitating that issue. The issue that has riled you, has caught your attention, you have thought it was unjustly decided. When you get an opportunity, try to get that corrected. Yes?
What you just mentioned, do you feel that the value of dissenting views in recent years have gone down earlier what it used to be? Like in latest, this is talking about in EWS case.
EWS case, yes.
He has a dissenting view.
Yes.
It used to be said that the dissent is actually what the near future will be.
Yeah.
And it happened in our own phase. But today the value is going down. Like I'm not sure that many of us will be aware about Justice Ravindra dissent right now. It will be just one judge might have dissented or dissenting views. But do you feel that the dissenting?
So there have been history is replete. The Supreme Court's history is replete in cases where dissents have become majority views. As the court has progressed in time. And just as an aside, as a trivia, who was known as India's greatest dissenting judge? No. I'm not talking about one judgment. I'm talking about a judge who wrote dissent after dissent after dissent. Yes. So the fact that you are in the minority or you're writing a dissenting judgment should not come in the way of that view being corrected tomorrow. He converted most of those dissents into majority opinions, right? So, anything else? Yeah.
So my name is Divyansh. I'm a first semester student.
Hi Divyansh. First semester? Wow.
Sir, my question is that you said that we should work on ourselves. But in what direction? Like in first semester, we have to focus on what thing? Like in academics or the other activities that are going on, like mood courts or India competition?
Do everything. My suggestion and my advice to you would be, do not turn yourself into a unidimensional person by focusing only on what is taught to you, your curriculum. And this is true also when you become a lawyer. Don't focus only on the work that you have to do. Develop interest. The Chief Justice of India recently said so. Build interest, pick up a hobby, because the law is not, although it is called a jealous mistress, it is called an all-consuming profession. It leaves you time to work on yourself, to pick up a hobby. For instance, my hobby is running marathons. I run, okay? There is enough time for all of us. There are people who Mr. Ghosh has a repertoire of hobbies. He is not one, he's got many hobbies. Okay? Satyakam's hobbies, the list is endless. Anuj's hobby is mediation. I don't know Miss Mattu well enough to tell you what her hobbies are. But
Knitting.
yeah, whatever. So whatever works for you, pick up a hobby. But that doesn't mean that because you are doing something that is slightly away from the mainstream, that you're wasting time. Okay? You are not wasting time if you pick up a book to read, or if you travel, or if you listen to music, for instance. That is your way of unwinding. The profession is a stressful profession. It is a profession that once you enter, you realize is very difficult to cope with. Find that safety valve, that pressure release valve that you can go to, and that helps you unwind. Okay? Yeah?
So, I want to speak for common man. I will use that particular language, but you will repeat for that matter. That सुप्रीम कोर्ट कई बार जब अपने जो भी दिशा निर्देश देती है, जो भी निर्णय लेती है किसी प्रकार से, कई बार वो काफ़ी ज़्यादा ऊपर, क्योंकि जजेस जो हैं वो पहुँच ही रहे हैं, ऊपर के तबके के लोग जो हैं मोस्ट ऑफ द टाइम इट इज लाइक दैट। या आप समाज से इतना अलग हो जाते हो पिछले 20-30-40 साल में, अगर आप पहुँच भी रहे हो वहाँ पास कि आप समाज की वास्तविकता से अलग हो जाते हो, तो आप ऊपर पहुँचते हो और आप फिर वहाँ से डिसीजन देते हो कि समाज को ऐसा होना चाहिए, बल्कि आप समाज से परे रहे हो पिछले काफ़ी वर्षों तक। एक सत्यता ये, दूसरी सत्यता ये कि जैसे जस्टिस CJI DY चंद्रचूड़ साहब का व्यू था सबरीमाला जजमेंट कि वी शुड गेट रिड ऑफ द रासो ऑफ मानी एंड वी शुड लुक फॉरवर्ड नाउ एंड ऑल दीस व्यूज और देयर, तो वो व्यूज थे। लेकिन ऐसे व्यूज जो कि समाज के नीचे जो तबका वो समझाते हैं कि पर्सनल लॉ कस्टम यूजेस सबसे नीचे जो तबके के लोग वहीं अभी भी सब उसके साथ चल रहे हैं, वो सब ज़्यादा उनको इफेक्ट करेगा। तो क्या कई बार सुप्रीम कोर्ट चूक जाता है ये समझ पाने में कि हमेशा आप ऊपर से सब पे थोप नहीं सकते, कई बार आपको लोगों को भी समझना होगा।
जी। So what you're really saying is the Supreme Court is sitting in this ivory tower.
Yeah.
There is a disconnect between the judges of the court and what the common man's aspirations are, what his needs, his desires, his beliefs are. I would put it slightly differently. The judges of the court are people, for that matter, any court, are people from amongst us, right? They have not descended from heaven.
Yeah.
They have not been paratrooped into the Supreme Court from some other alien universe. They are people who have lived the life that we live. Some of them may be more affluent than us. They may be coming from backgrounds that are more privileged than the Aam Aadmi. But yet, they are all Indians. They know what the problems of this country are, what its challenges are, how those challenges need to be met and answered. So to say that the court is really not in sync with the needs and the desires of the common man may not be necessarily correct. You spoke about Justice Ravindra Bhatt's judgment in the EWS case. Shows that the court has a connect. The judges of the court have a connect with what is required for this country. There are aberrations. There are aberrations in every walk of life. There are aberrations in every profession. It is not, it's simplistic in a certain sense, according to me, to say that the judges do not know what the common man wants, right? If judges do not look forward or not forward thinking, very many ills that plague our society would never get addressed. Ms. Mattu yesterday spoke about the Vishaka judgment, okay? A judicial evolution that has today seen a law being brought into place, right? A positive impact that the court has brought in. So, according to me, the court has really been the torchbearer of civil liberties and human rights in this country, and it has always shown India the way forward. Yeah.
My name is Aditi.
Hi,
Like my batchmate, Divyansh asked the question.
So first semester?
Yes, sir.
Oh wow.
So taking forward that question, you told that we should work on ourselves, on our hobbies. But
Right.
as a first year students, we are losing ourselves. Our interests we are losing because we are so much focused about our academics, all those competitions. So how can we maintain a balance for ourselves and with the law? Like we should remember our priorities also. We are also humans at the end. So can you please suggest how you maintain your life, like your hobbies with your career?
Yes. So like I said, my hobby is a very mundane hobby. I like to run, right? There are days on which I do not manage to get time to run. But by and large, I make it a point to do that at least 3 times a week. I may not be able to do it every day. I get up slightly earlier. I've got a brief, and as a practice, there are lawyers who will read through the night. I read in the morning for the next day's cases. I take my files home. I get up slightly earlier, read, go for a run, come back and read again before I go to court. You have to be able to find time within the 24 hours allotted to each one of us to do what is important. Okay? And I'm not saying important only for the law. You have to find time for yourself. If you don't work on yourself, you will burn out very soon. Okay? So you need to be able to balance the work-life balance that somebody else spoke about yesterday. It is important. You need to be able to give time to yourself, to your family, and do things that help you unwind from the stressful profession of law. Right?
Thank you, sir.
Yes, sir.
I'm Harshad.
Hi, sir.
Sir, my question is, when is the right time to branch off from your senior?
Yeah, so that is a question that I thought I'd address. I started my talk with this thought. There is this sense of impatience that I have seen in this generation, okay? And that is, I think, brought about by peer pressure. You feel that your senior, your immediate senior, or somebody 2 batches senior to you has gone independent. So the clock is ticking. Your time is running out. If you don't branch off today, the world is at an end. There will be nothing left. All the work will be taken away by somebody else. Look here, I am working for somebody, I am slogging my backside off, working on somebody else's matters. When my colleague or my immediate senior is arguing in court on his own or her own, why should I not branch off? According to me, I worked with my senior for 10 years before I set up my own office in 2010. I don't think there may be people who've done far more than I have, and I'm sure there are. But I think those 10 years enriched my life to no end. Okay? We had in India, this may sound corny to some of you, the Gurukul system, where you learned under your senior. That system, unfortunately, today is really being ignored. This urgency or this desperation to set up your own office and see your name on a board outside some physical space, please do not fall prey to that. Work with somebody, that person will teach you the ropes of the profession. And once you build that rapport with your senior, your profession will be much smoother, believe me. Okay?
So it's a complaint that I see from other graduates from DNLU that they are working and some seniors and they see that they are not doing or something. They complain as such. So in this regard, sir, what can be an indication that you should get independent?
See, there is no right time. There is no bell that will ring which will tell you that, okay, I need to branch off now. Okay? Left to myself, again, I'm going back to my own story, I wouldn't have left my senior. Okay? In 2010, he told me that it is time you should branch off. Now that may work for you, it may not. But the singular quality that you need to be able to develop in yourself is one, patience. And आप लोगों ने शादी में देखा होगा ना वो घोड़ा जो जिस पे दूल्हा बैठता है, the घोड़ा has this thing on his head, है ना, that covers his eyes, right? And he is not looking right or left because वो ढोल बज रहा है. All of that just to protect his sense of self. That thing is put on his head so that he doesn't get disturbed and doesn't start, You need to develop that ability in yourself. Focus on where you want to be. Don't look right, don't look left, don't see, where the person to the left of you or to the right of you is going. What he or she is doing. That is irrelevant. Every one of us have our own journey in life. We have our own story to tell. We have our own trajectory. Some may rise faster than others. But that is immaterial in the larger scheme of things. Okay? What you do today, do it patiently, do it wholeheartedly. Give yourself to each task completely. Be consumed by it. Do not worry about this persistent need to branch off. That is immaterial. When the time comes, you will know for yourself. For instance, just to give you one quick answer, there could be a situation where while working with somebody, you start getting a lot of independent matters. Okay? Clients may start approaching you. Okay? What do you need to branch off? You need to have enough work coming in to sustain yourself. Because once you leave, what will you lose? You leave an established infrastructure. You leave the comfort of a paycheck coming into your account every month. right? You will leave, and most importantly, what I missed most about leaving my senior's chamber was the everyday interaction that I used to have with him, in court, in office. On a daily basis, I used to be able to speak to him. Even today, I miss that. Right? So, think for yourself what is important to you, and don't be in a hurry. The profession, people practice till the day that that's the best way for a lawyer to pass on at his desk or arguing in court. Lawyers work up till the age of 70, 80, 90 if their body permits it. So there is no clock that is ticking. Okay? Right.
There is one.
Yeah, last question.
There is this advice that I had got earlier from some of my seniors that you should join AG office, government side, because there's so much of work and there is always in a hurry. But there is also a downside that I feel that you would start thinking from the government side. So
Why is that a worry?
because when you go,
The government also has its own story. I have been a government lawyer now for about 7.5, 8 years, right? But over 50% of my work is private work. Okay? I don't think that because I work for the government and I've worked for different governments, that I have become biased in any manner or that I can't see the private litigants side of things. That doesn't happen. And I agree with that suggestion because a government chamber gives you such a huge volume of work that you will not see in private practice. Right? If a government lawyer, for instance, handles 10 cases or 20 cases on a daily basis, a private lawyer may have 1 or 2. And how does a lawyer improve? By reading more cases, by working on a diverse area of law, dealing with issues that may not really come your way when you're in private practice. So if you have the opportunity, grab it.
It is a possible time.
Yeah. All right. Thank you all. Thank you.
Thank you, sir, for gracing our institute with your esteemed presence and providing us with such valuable information. So on behalf of all the students present here, I would like to thank you for answering the various questions raised by our students and imparting your valuable wisdom on the practical aspects of the profession, which all of us are soon to enter.
Thank you.
Thank you.